Hello, friends! Wake up! I'm Joel and you're watching Peace in America. Today, I'm going to show you how to argue in front of the United States Supreme Court. We're talking a little edutainment. This video will help you level up your public speaking experience, which is valued in every field. We will enhance your legal knowledge by taking you inside the courtroom to hear from the world's best lawyers arguing real-life cases. We will examine the analytical abilities of the great legal minds of our time and try to figure out how to improve our own legal analytical abilities and become highly trained professionals. Law students and practicing lawyers are going to love this stuff, but I want non-lawyers to watch this too. Everyone has something that they can learn and take away from this video and help themselves in their career and their daily life. I have chosen clips from the great advocates of our era. I will use these clips as teaching moments. I will ground those examples by teaching you the fundamentals to oral argument. This video is going to give you more wings than Red Bull. After you've watched this video 5 times, you'll be flying around the courtroom like a pterodactyl. Warning, warning, this knowledge is highly concentrated. One should be advised and exercise their discretion if they're going to watch this video while driving a vehicle or operating heavy machinery. It's time for some edutainment. We're gonna lay the foundation of your analytical minds. I will show you there are levels to this game. So what is oral argument anyway? To answer that question, what is an oral argument? You need to understand the role an oral argument plays in deciding an appeal. The types of arguments we're discussing involve arguments in appellate court, so you need to understand the process for deciding an appeal. Here is the general outline for the appeal process. First, a party files an appeal of a court's decision. Usually this will be a trial court or an intermediate appellate court, and that party is asking the decision to be reviewed by a higher appellate court. Once the appeal is filed, the parties file the record of the trial and the evidence as well as their briefs, and they submit that to the court for the court to review. Next, the appellate court reviews that record and the briefs. Members of the court will prepare an internal memorandum. The memorandum will summarize the key facts, the controlling legal authorities, and the issue presented or the dispute that the parties are bringing to the court for resolution. Each judge will have read the briefs and that internal memorandum, but not every single judge will read the entire record of the trial. Next, the court hosts oral argument for the case. And now the most important step for understanding the role that oral argument plays in deciding an appeal. Immediately after oral argument is concluded, the judges meet together in a conference to discuss the case and the argument that just happened, and they will take an initial straw poll on how they think they might vote in deciding that case. This is not a binding vote, but this tells each other what they're thinking and where they're likely headed. Therefore, you should understand oral argument as the last chance to influence that conversation where the court is about to decide your case. Oral argument is your chance to have a voice in the room where it happens. After that initial conference, the court drafts a written opinion that it will circulate to other members of the court, and revisions, edits, suggestions will be passed back and forth. Eventually, they will have a meeting over a submitted opinion and will take a final vote on whether to adopt that written decision as an official opinion of the court deciding the appeal. As a general matter, it may take anywhere from between 3 to 6 months between the time the case is argued and that official court opinion is published to the public. In some cases, it will be a shorter turnaround, but in a lot more cases, it will be a longer turnaround. One of the most common questions of oral argument practitioners is how important is the brief in comparison to the oral argument? The truth is, the briefs tend to do the majority of the work. One of the common answers you might hear on this question is that the briefs do about 90% of the work and the oral argument does about 10% of the work. But the thing is, with these cases, everything counts. Think about if you have a close case, that 10% is going to matter a whole lot. You might think of it as the fourth quarter in football or basketball or the ninth inning in baseball when it's a really close game and either team can win. Therefore, oral argument can help you win a case. And if not help you win the entire case, can help you win certain issues within your case. And what is definitely true is that you can lose a case during oral argument, and we will see some real world examples of this happening. Your basic structure of any oral argument is going to consist of a brief introduction, roughly 30 seconds to a minute. Then the advocate will give a roadmap of where she is going. The classic phrasing of this is she will tell you where she's going, she will tell you, and then at the end she will tell you what she just told you. After the roadmap, there typically is a brief discussion of the facts, especially those that are most important and will decide the legal issues. However, our examples today are going to be focusing on the United States Supreme Court, and in the modern day, a long discussion of the facts is not as common. The game that's played today is much more rapid fire. After some discussion of the facts, that's when you have your argument, which is going to consist of the outcome you propose, the actual relief that you're requesting, the specific thing that you're asking the court to do. And you're also going to have counter arguments because there will be two sides presented to the court at minimum. And so you're going to have to respond to what the other side is saying. Then after the main arguments and supporting legal analysis is presented, there will be a brief conclusion, again with a specific request to the court asking either for a reversal of the decision below or some kind of specific relief, like please invalidate this statute. And then you have rebuttal. The petitioner, the party asking for reversal of the decision below, has a chance to go first and last, and will have a chance to respond to the entire presentation of the party who's asking the court to affirm the decision below. So the rebuttal is the last time that the court will hear from the advocates, and it's a chance to end on a high note and with a powerful punch. Our first example is going to come from none other than Chief Justice of the United States, John G. Roberts, who in his day was the man when it comes to dominating the oral advocacy scene. And in my opinion, I think he's the third best oral argument I've ever heard.
We'll hear argument now in number 89-640, Manuel Lujan versus National Wildlife Federation. Mr. Roberts.
Justice, and may it please the Court. This case is here on certiorari to the United States Court of Appeals for the District of Columbia Circuit. That court held that respondent had standing to challenge hundreds of Bureau of Land Management land orders entered over the course of several years, affecting 180 million acres of public lands in 17 states. The court concluded that a single affidavit of one of respondent's members, Peggy K. Peterson, was sufficient to confer that standing. In her affidavit, Ms. Peterson claimed that she used federal lands in the vicinity of the South Pass Green Mountain area of Wyoming, and she claimed that she was injured by a BLM decision to open that area to the staking of mining claims. The district court found that the area in question covered some 2 million acres, of which only 6,000 acres had ever been closed to mining. And of those 6,000, the BLM decision only opened 4,500 to the staking of mining claims. The court noted that Peterson's affidavit said nothing about using the 4,500 affected acres, and therefore concluded that she had shown no injury and that respondent therefore had no standing.
But she also claimed about lack of access to information, didn't she?
That claim was in the Greenwald Declaration, one of the other of the three original affidavits that were submitted by respondent. The claim there was that the organization had standing in its own right, without regard to any injury to its particular members.
But it's in your case.
Yes, Your Honor. And the district court, we believe, correctly concluded that that declaration, the Greenwald Declaration, was completely conclusory and devoid of specific facts. But more important, it's really just Sierra Club against Morton all over again.
But the Court of Appeals thought otherwise.
With respect, Your Honor, no, it did not reach the Greenwald Declaration. It didn't pass on that, choosing to rest its decision entirely on the Peterson affidavit. The district court, however, did address the Greenwald Declaration and found it, as I've indicated, conclusory and devoid of fact. It is, as I've mentioned, the Sierra Club case all over again. In fact, it's helpful to compare the allegation of standing in the Sierra Club case with that in the Greenwald Declaration. They're really quite similar. Each of them says, our organization has experience and expertise in conservation. We're vitally interested in this issue. In the Sierra Club case, the affidavit said, "We responsibly serve and represent our members." In the Greenwald Declaration, Ms. Greenwald claimed that the organization needed information and public participation in order to represent their members. But this court, in the Morton case, said that that sort of interest was insufficient to confer standing because it was in no way distinct from the interest any citizen could claim coming in the courthouse and saying, "I'm interested in this subject." Turning back to the Peterson affidavit, what Ms. Peterson claimed was that she used land in the vicinity of this 2 million acre parcel, the South Pass Green Mountain area of Wyoming. The D.C. Circuit on appeal presumed that she meant to say something else. They presumed that she meant to say she used the 4,500 affected acres. The reasoning was that she claimed that she was injured, claimed that she had standing, and she would only be injured and only have standing if she used the 4,500 acres, and therefore she must have meant to say that she used those 4,500 acres. This is exactly backwards. Federal courts are courts of limited jurisdiction. The presumption is that they are without jurisdiction, and the plaintiff must affirmatively prove that he has standing to invoke the power of the court. The Court of Appeals presumed Peterson meant to say she used the 4,500 acres because otherwise she wouldn't have standing. But what Peterson said is that she was in the vicinity of this 2 million acre area, not even within the 2 million acres, just in the vicinity. Even assuming we can place Peterson somewhere within the 2 million acres, the Court of Appeals had no basis for drastically narrowing the focus of her allegations on the 0.225% of that area that was the only area affected by the challenge decision.
So you can really feel how smooth John Roberts was in his argumentation there. He has full mastery of the pace and the clarity of his voice and tone and enunciation, and he speaks very carefully, knowing that each word he chooses can dramatically affect the legal argument he's making to the court and the thing he's asking the court to do. So he's very careful, but the way he advances forward is almost as if he's helping you think through the position to where you can start agreeing with him and go with him and analyze the case the same way he does, because he's so workmanlike in his approach and so persuasive without missing a beat. Really, you can tell that this was a man destined for great things. Early on in his Supreme Court oral advocacy, he almost seems as if he's already one of the members of the court. Now let's take a modern day example. This is Adam Unikowsky in a case called Artist versus District of Columbia in 2016. It's a really great example of a petitioner jumping right out of the box with a very clear argument, well articulated so that it will not be misunderstood. Once he's done that, the rest of the argument is a cakewalk because he's set up his position very clear, and it's up to the others to come up with something better than what he's proposed.
We'll hear argument this morning, case 16-460, Artist versus the District of Columbia. Mr. Unikowsky.
Mr. Chief Justice, and may it please the Court. Title 28, Section 1367D specifies that the period of limitations on a supplemental jurisdiction claim shall be tolled while the claim is pending in federal court and for a period of 30 days after it is dismissed. The question before the Court this morning is, what does it mean for a period of limitations to be tolled? The Court should hold that tolled means suspended, an interpretation that accords with the plain meaning of the word tolled. That is the definition given in Black's Law Dictionary, and that is the way tolled is used in every other statute that uses the word tolled, none of which would make any sense under Respondent's interpretation.
If that's the way the statute operates, it seems to me that the provision at the end, which says the state can provide for a longer tolling period, is generally unnecessary. Under your position, it would seem to be quite unnecessary for the state to have a longer tolling period.
Your Honor, states could.
Now, it could be, of course, that they're concerned about there being only a week left or something, but in most cases, under your view, I just don't see the necessity for the last clause.
Your Honor, it's true that typically the state savings clause won't necessarily be triggered, but there are certainly many sets of facts in which it would be triggered. First of all, a state could enact a tolling period that's even longer than the federal tolling period. Louisiana, for instance, actually restarts the clock.
But they couldn't enact a shorter one.
It could not. That's correct. I think this is a federal.
In other words, your position gives the states zero flexibility. The respondents give the states maximum flexibility. States can have it any way they want, but you don't give any protection to the states that don't want to have long delayed suits.
Yeah, it is certainly the case that this statute provides a federal floor, and we're debating about the length of the federal floor, and we believe that the federal floor is longer than respondents do, and the effect of that is that it's true that under our position, the state tolling, the savings clause will be triggered less frequently under our view, but that's simply the necessary implication of the plain text of the statute in our view.
Why is it the plain text? Because 1367D refers to the 30-day period as a tolling period too, but that period is recognized as a grace period, the 30-day add-on. The federal statute types that as a tolling period, but it isn't, is it?
Your Honor, the way we interpret the statute is that the clock stops while the claim is pending in federal court and for 30 days after it's dismissed. So we understand the phrase tolling period to refer to the period during which the clock stops. So we view that 30 days as part of the tolling period.
Well, does toll and do toll and tolling mean the same thing?
I think that in the context of this particular statute, tolled means suspended. So I think that it's true that in general, when, there are, for instance, the Chardon case says that in general the word toll can carry different types of meanings.
You should be aware what the court is expecting is not necessarily an argument like a counsel would in a presentation to a jury. This is more so a conversation among intellectual peers. Don't try to go for emotion, and don't try to go for something that's so rigid and inflexible that you just want to say take it or leave it to the court, because that's not how it works. It really is a respectful conversation that you must be engaging in, and it's your job to be the one in the room who knows the most about the case, even more than the justices. The tone is explanatory rather than confrontational or browbeating. It's more of, from an intellectual standpoint, explaining the legal reasoning within the already existing law and explaining how everything is in harmony and how the same would be true going forward. The goal is to persuade the bench and ultimately to get more votes than the other side. Persuasion comes through speaking clearly and answering questions directly.
Please answer the question.
There's a method you can follow called LAF, L-A-F. Listen, answer, follow through. I can't emphasize enough how important listening is. The arguments you are presented in court may not be exactly the same as what you expect. Step one is to make eye contact, which means you're not reading your presentation. You're looking them in the eye, and when they're speaking, you listen very closely because their question may surprise you. And then the key is answer the question.
You want answers? Don't change the subject!
Try to begin your answer with a yes or no, and then explain, instead of leading with the explanation. If you lead with the explanation, the court is not going to listen. They're going to be wanting to know, is this a yes or a no? And they're going to be wondering why you didn't say yes or no. If you really can't answer yes or no, it's fair game to answer it depends, Your Honor, if I may explain why. But definitely have a short answer first and then extend to the explanation. That's the only way the court is going to listen to this stuff that you've been working so hard in preparing. That's the follow through. Just like in the game of basketball, when you're shooting a jump shot, or golf, when you're hitting off the tee, you want to follow all the way through. Following through means once you finish your answer to the question, you can go right back into your presentation and present the most powerful points that you've wanted to the whole time. One tip to keep in mind is don't ask the court, did I answer your question, Your Honor? It creates an awkward moment for the court. It almost is asking for information from the court, which they may not want to give. Trust me, if you haven't answered the question, they will let you know. But what you should be doing is trying to steer traffic, answer the question, and move on to your strongest points. So all of this takes a lot of time, work, practice, repetition, and moot courts. It really may take a lot of time to get into that conversation mode that I've been talking about. So I have a couple examples of real life cases where amazing oral advocates just didn't get started off on the right foot, but they made an adjustment in their our presentation that did land them back on track into the proper conversational method. And I'll show you two examples here. The first example of this comes from unbelievably good Supreme Court advocate William Jay, who is a descendant of the first ever Chief Justice of the United States, John Jay. And you'll see here in that his first ever oral argument in front of the U.S. Supreme Court, he starts his presentation speaking a little bit too quickly, and Ruth Bader Ginsburg offers a suggestion that helps him disrupt the pace so he can reset.
We'll hear argument next in case 07308, United States versus Clintwood Elkhorn Mining Company. Mr. Jay.
Mr. Chief Justice, and may it please the Court, respondents sought and received a full refund of the tax they paid on exported coal for the full 3-year period permitted them by the tax refund statute. What the Court of Appeals decision permitted them to do was to bring an additional action for indistinguishable relief, but for a 3-year period beyond what the tax refund statute permits. We submit that that decision was erroneous for two principal reasons. First, the plain and unambiguous—
It might help if you raise that lectern a bit.
Is that better, Your Honor?
Yes.
Thank you. The plain and unambiguous terms of the tax refund statute, Section 7422A, expressly provide that any claimant who alleges that a tax has been illegally assessed, no matter the reason, must, before proceeding to court, file a refund claim with the Internal Revenue Service within 3 years after filing the tax return on which the illegal tax was paid.
Next, we have an example from Solicitor General Don Verrilli, who somewhat infamously, when he was arguing the Affordable Care Act case in 2012, had a little bit of a dry throat. And it was a really big day at the court because there had been so much debate over whether the Affordable Care Act is a proper exercise of Congress's commerce power. So there was a lot of pressure on Don Verrilli. This was an enormous act that was passed through Congress with 60 votes, but now it was before a court that may have been skeptical. There was a lot of focus and attention on him, and people noticed that he had to stop in the middle of his presentation and took a drink. But it was ultimately smart that he did this.
We will continue argument this morning in case 11398, the Department of Health and Human Services versus Florida. General Verrilli.
Mr. Chief Justice, and may it please the Court, the Affordable Care Act addresses a fundamental and enduring problem in our health care system and our economy. Insurance has become the predominant means of paying for health care in this country. Insurance has become the predominant means of paying for health care in this country. For most Americans, for more than 80% of Americans, the insurance system does provide effective access. But for more than 40 million Americans who do not have access to health insurance, either through their employer or through government programs such as Medicare or Medicaid, the system does not work. Those individuals must resort to the individual market, and that market does not provide affordable health insurance.
I'm going to hit you with some do's and don'ts, and then we'll get into a lot more specific examples. Do's and don'ts. Number one, do know your case. That fundamentally means knowing the record in your case more than anyone else in the room. The judges have lots of cases, but this has to be your case and your responsibility to own this case. And there's a lot of benefits that come with that. Knowing the facts means you know which legal decisions out there are the most on point and the most relevant and applicable. In any appeal, there will be a lot of debate as to whether this case controls or that case controls. But a lot of that comes down to the hard, cold facts of the case. This is going to make all of your answers more confident because you know where you stand. And it will allow you to educate the court as to the case because they don't know it as well as you do. This will help you as to exactly what your answer should be and how far you should go in answering certain questions and when to stop and draw the line. When you're arguing in an appellate appellate court, the court is going to be much more likely to be familiar with the area of the law, but they're not necessarily going to be as knowledgeable of the entire record as you are. So a lot of the questions you may get are going to be specific facts. So it's your job to find the answer and to know the citation to the record so you can point the court and its staff as to where to find this information. Number 2, do know your opponent's case. There are going to be 2 sides at least to this story. It's all a game of comparison. Maybe your case is only so-so, but you know the other case doesn't have a chance. Knowing the other side's case is going to help in your preparation. It's going to help you anticipate questions you might get from the court and arguments that you're going to have to respond to during your time at the lectern. Number 3, do a great job of framing a very clear issue for the court to be resolved. Many different cases can be a debate of framing the issue, and if you're able to successfully frame the issue, a lot of the logic and reasoning that you present will naturally follow. If the court agrees with your framing of the issue, they're more likely to agree with you all along the way, including the answer that you propose to the question that's being presented. Having a clear, durable framing of the issue is going to help you out throughout your argument and is going to be harder for the other side to mischaracterize. As a general rule of thumb, if you're the appellant or the petitioner, your rule or framing of the issue is going to be about an error that was committed below and while reversal is necessary. And if you are the respondent or the appellee, your framing of the issue is going to be relying on that lower court decision and defending the authorities presented in that decision and essentially advocating that order as one that should be affirmed. Number 4, do prepare to answer the question that you fear the most. Knowing your case better than anyone else means that you know the weaknesses of your case, and you need to be prepared to defend those weaknesses because you can rest assured that those weaknesses will be aired and evaluated. There's nothing easier for the other side to attack, and there's nothing easier for the court to question. You're going to need to deal with that one way or the other because the court is going to need to deal with that. You need to anticipate that and take preemptive measures so the court is not concerned with it based on your proposed resolution. You have thought of a way to deal with this that's going to make the court's job easier of agreeing with your ultimate outcome that you're asking for. And as you prepare to answer the question that you fear the most, it's also helpful to prepare a transition to a different affirmative point as almost a escape route or an emergency escape hatch. Get out of that area as soon as you can and go on to a part of your case that's strong. If you're not sure how you're going to get out of that scary part of your case, one tip I did here is that you could relate it back to another question earlier in the argument from another member of the court. You could say, "Thank you, Your Honor, and that reminds me of another question that was asked by Justice Brown earlier," even if maybe it's not exactly on the same topic as you were addressing, but it's a good little tool that you can use that's not too cheesy or too obvious. Number 5, do present sound legal reasoning in your case that will apply in other contexts. There's a classic saying with appellate courts, their job is not really to care about your case, they care about the next case. When we're talking about appellate courts, they are dealing in the law. So it's not necessarily all about the case of Mr. Smith versus Mr. Jones. It's about having an orderly system of jurisprudence that's going to be able to address a case like Smith versus Jones, as well as the next case and the case after that and the case after that. That's what the purpose of the hypotheticals is. It's to test the soundness of your legal theory.
Suppose you law. Any liquor store has to use paint made in Tennessee, asphalt made in Tennessee for the parking lot, neon. I can go on.
6, when you're answering hypothetical questions, try not to argue that isn't this case, Your Honor. The court knows that. That's not the reason why the court's asking this question. They really want to know and they want to get into the legal analysis and test your legal theory. So you need to do your best not to have that reaction of that isn't this case, Your Honor, and instead engage in the exercise. Take advantage of the opportunity to show your theory is sound and your theory is better record. In some ways, this is difficult to avoid because maybe your case really is different, and I understand that. But give that answer of this is a different case later on in your answer. Certainly that is fair. And when you do that, come back to that detailed knowledge of the record with supporting citations to show that, Your Honor, your concern actually isn't applicable because this page in the transcript says that this is a different situation. We can carefully and comfortably place this in a different category of cases. So therefore, Your Honor, having answered your hypothetical more than just saying this isn't the case, you can have a more substantive answer and illuminate the court on what is really going on about your case. In dealing with hypotheticals, the court likes to adjust it a little bit more and a little bit more and a little bit more just to test again the theory and where the line is and where the rule might bend and break. Speaking of knee-jerk reaction answers, one of them is, well, Your Honor, that would be a harder case. And while it's probably true and you are engaging in the exercise, definitely try to add more to that answer. Try to actually give an answer. Try to put yourself in the role of the court and play out how this hypothetical would work, speaking the court's language of what they're trying to do in this exercise of hypothetical questions. Number 7, do be flexible. Oral argument is really more of a conversation amongst the judges, and you're just standing there in the middle. That means you're not going to talk about an issue as much as you would like. What you need to do is get comfortable with that situation, be flexible, and do your best within it. The court knows that you've worked hard in this case, and there are certain things that you want to be able to have an opportunity to present. But the court has also worked hard in this case, and they have specific questions that they have not been able to answer. They want you to help them find an answer. So whenever a court asks a question, it's very important to you winning your case, and it's more important than answers you'd plan on giving just because they're the strongest part of your case. The key to winning is answering those difficult questions and working with the court on where they are at and trying to listen to them, see the dispute through where they're sitting, and help them along the way. Do be flexible in recognizing there's more than one way to win your case, and just because it's not the way that you thought of or that you prepared in your preferred method, there still is another way that might have a majority of votes, and you should be ready and willing to embrace that. Also, part of knowing your case means knowing when to make strategic concessions, knowing where you can draw the line in terms of what you need to win and what you don't necessarily need to win. But when you do have a concession you can make, that can actually strengthen your case a lot and enhance your credibility with the court because they now know this person is working with me. Number 8, when you're answering a question, do answer yes or no and then provide an explanation. Number 9, do know the applicable standard of review and be prepared to discuss it. If it happens to be a standard of review that favors your case, emphasize that at the beginning and explain why your argument meets the standard of review on appeal. And if you happen to be in a more difficult situation where the standard of review is not as forgiving, you need to acknowledge that, recognize it, and explain why, despite the high standard, your case still meets that high standard. There's a number of different standard of reviews that may be applicable depending on the issue that you're appealing on. And they have a range between how deferential is the appellate court going to be to the lower court that it's reviewing. And it's from a scale of number 1, de novo, which is the least deferential. It's literally deciding the case anew, which means there's no deference whatsoever. And this is typically done when there is a pure question of law presented. The appellate court's in charge of saying what the law is. And so just because a trial court has worked hard doesn't matter. It's starting over from scratch in terms of the standard of review. Then there's other more difficult standards of review, something like a clearly erroneous standard of review. Let's say there was a jury trial and you lost, and on appeal you're saying there was something wrong with the record. This is a situation where immediately the appellate court is going to be more deferential to the lower court. They don't want to have to redo every single case, and so in order to win an appeal, you're going to have to convince the appellate court that they have a firm belief and understanding that there was an error committed. Another more deferential standard of review, and therefore one that's difficult to win on an appeal, is called abuse of discretion. And this involves, for example, all the different decisions that a trial court has to make in conducting a trial, whether it's allowing certain witnesses and witness testimony, allowing certain arguments. The appellate court may think, I would have done it exactly the same way, but is there an error here? Is there something that went outside the bounds of discretion that's normally afforded to the trial court, which is a pretty wide amount of discretion. And to meet the abuse of discretion standard of review, usually you need to prove that there's been some violation of legal rights. And that falls outside of the bounds of the trial court's discretion. So again, each one of these as we go is more difficult. Then there's a standard like arbitrary and capricious. This is a very difficult standard where your task is to prove that the decision below was just arbitrary and is one not made on reason, but this is just something they chose to do because they chose to do it, and that's it. And that's difficult. And typically, if there's any evidence in the record that could rationally support this type of decision, the appeal is going to lose because the standard of review is so demanding. But that's another situation, typically like an agency appeal, where the losing party appealing has to meet a high burden. And so if they're going to appeal the decision, they might as well state at the outset that they can meet this burden. Otherwise, it's just a huge waste of time. And lastly, there's a standard of review known as plain error, which technically could be at issue in every single appeal because the idea is that something happened in this case that is just so contrary to law and so unacceptable that this cannot be allowed in a civilized society. And if it were allowed, it would allow the public to lose confidence in the court and the justice system. And again, it's another option, and it's something that an advocate should know because plain error sounds like any error that you find, you win, but it's not true. You should know the definition of these terms, the legal meaning of these terms, and the tests that each term sets out and what is required in order to win. Now the don'ts. Now we're going to cover some don'ts. Number one, don't read. Seriously, don't. Force yourself not to read. Once you do this, you will immediately notice that you've gone up a level. Now you're engaging in that eye contact, conversation, back and forth. But if you're reading, it really just doesn't help at all. You've already submitted briefs and you're just kind of hiding and trying to get out of doing your job. So don't read when you're at the lectern. This is the fastest way to make huge, immediate leaps and bounds improvements in your argument style. Here's an extreme example of what not to do. Don't spread or speed read. If you're a debater like I was, you're familiar with the term spread. In debate, in the constructive arguments, you're given 8 or 10 minutes, which forces debaters to read material and speak as fast as they can in order to get the most information submitted within that allotted time. But the sad truth is that this is a horrible habit. Here's an example of what spreading looks like. This is me trying to speed read the United States Constitution, including the preamble and Article 1. The Constitution of the United States Preamble, we the people of the United States, in order to reform a more perfect union, establish justice, ensure domestic tranquility, provide for common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our prosperity, to do ordain and establish the Constitution of the United States of America. Article 1, Section 1, all legislative powers herein granted shall be vested in Congress of the United States, which shall consist of Senate and House of Representatives. Section 2, 1, the House of Representatives shall be comprised of members chosen every second year by the people of the several states, and the electors in each state shall have the qualifications requisite of electors. The most numerous branch of each state, the legislature. The unfortunate thing is, in real life, I have seen an oral advocate spread 2 arguments in a row back to back, and it was just a complete failure and missed opportunity because it doesn't allow for any of that conversation that I've been talking about. And it is really just odd thing to see that this is happening. This person is speed reading through their arguments and just getting absolutely nowhere. Number 2, don't lose your cool. The questions that you're going to be given are tough questions, but it's not personal. Don't let it get under your skin. Don't get trapped into thinking that the court is your adversary. The court is not your adversary. The court is your friend. Try to remember the court is your friend and smile and work with them, even if you're discussing difficult issues that may not be favoring your client. I have a bit of a personal story on this. I can remember my worst ever oral argument was because I did lose my cool. And I even remember things like I had a Jimmy John's sandwich delivered before my argument, but I decided not to eat it because I was too nervous. But then it was like I lost all my energy and I was on empty. And I was like, maybe I should have ate the sandwich. And then when I got up and argued, I was all hangry and I was getting asked questions that I knew the answer to, but my attitude was just way off. And then when I would try to give my answer, the judge kept interrupting me. grilling me. And this was on purpose, tried to challenge me more and see if I could handle it. And I definitely flunked the test. I just got more mad, and I got my answers out, but I was basically yelling and talking down to the court. And yeah, I definitely lost that one. That was a teaching moment, and that was tough. I tried really hard, but just in the moment, I just didn't have it, and I lost it. So it's super, super important to try to stay in the moment, keep your cool. And if you do lose your cool, go ahead, take a moment to readjust, take a sip of water, do whatever you need to do to get yourself back into the right state of mind where you can persuade someone. Because if you lose your cool, there's nothing more unpersuasive. So by keeping your cool, that's going to preserve your opportunity to show your best work, to show what you've worked hard on, to show that you understand your case, you understand your opponent's case, you understand the court's position and the issues they're dealing with, and you do have an answer, and you want to tell the court your answer, and you just need to keep your cool and take a chill pill and chillax. Also, part of this is being reasonable. You can't be the court's friend on every question they ask you because you're representing your client. Courts don't typically like it when you're fighting the hypothetical, but if answering the question in a certain way means your client will lose, you have no other choice but to reject whatever the court is suggesting. Number 3, don't feel like you must address each of the justices by name. I feel like a lot of the arguments I've seen, people like to gain style points by showing that they have some level of familiarity with the court by addressing each member of the court with their last name. But I would counsel against trying to do this. Number 1, there's just not much upside, and the risk is not worth the reward. Usually they don't have that level of familiarity. They're going to pronounce the last name wrong, or they're going to have the completely wrong last name. Sometimes maybe if you're trying to clarify the discussion and refer back to a question that was asked by a specific member of the court, okay, now if you really are ready for it, you can address them by name, saying it was Justice Brown's question. But notice that you are playing with fire. And don't do this unless you're ready. Oral argument is a lot like Mario Kart. Everyone's got a banana, everyone's got a green shell, everyone's got a red shell. Sometimes they have a mushroom, sometimes they have a star. They're coming for you. And there's so many ways to slip up. So unless you're ready for the final level of Mario Kart and you're ready to try to win first place on Rainbow Road, I suggest foregoing that desire of calling the justice by their name and say, Your Honor, Judge, Mr. Chief Justice, whatever it is, just be respectful, and that's acceptable. And here is a legendary example of someone who is well-intentioned, just keeps messing up the name.
This question, if you did have a situation, I know your position is different, where there were some uncounted ballots due to a machine malfunction, for example, would it not make sense to assume that the standard you used for damaged ballots would be the same standard you use in that situation?
I don't think so, sir.
What standard would you use in the situation I proposed then?
Justice Brennan, the difficulty is that I'm sorry. That's why they tell you not to do that.
If you don't use that, what's that standard? What standard would you use for my hypothetical?
The legislature would have to create one, sir. I don't know what standard.
You're saying that they can't interpret a statute in which there is no explicit definition.
What I'm saying is
they have to throw their hands up.
No, Justice Breyer. What I'm saying is that
I'm Justice Souter. You better cut that out.
I will now give up.
Mr. Clark, I'm Scalia.
Yes, sir. I remember that.
Correct me.
It will be hard to forget.
Here's a couple examples of attorneys where they were able to lose their case at oral argument. It's unfortunate. It's pretty cringeworthy. That's why you need to know your case. That's why you need to know what's inbounds and what's out of bounds, where you're going, and how to transition out of those tough points. Because once you're caught and pinned down into a corner, it can be very, very difficult.
The Constitution required Congress to draw the line where it did, limiting this to broadcast, cable, and so forth. What's your answer to Mr. Olson's point that there isn't any constitutional difference between the distribution of this movie on video demand and providing access on the Internet, providing DVDs either through a commercial service or maybe in a public library, providing the same thing in a book? Would the Constitution permit the restriction of all of those as well?
I think the Constitution would have permitted Congress to apply the electioneering communication restrictions to the extent that they're otherwise constitutional under Wisconsin right to life. Those could have been applied to additional media as well. And it's worth remembering that the pre-existing Federal Election Campaign Act restrictions on corporate electioneering, which have been limited by this Court's decisions to express advocacy.
That's pretty incredible. You think that if a book was published, a campaign biography that was the functional equivalent of express advocacy, that could be banned?
I'm not saying it could be banned. I'm saying that Congress could prohibit the use of corporate treasury funds and could require a corporation to publish it using its.
Well, most publishers are corporations. And a publisher that is a corporation could be prohibited from selling a book?
Well, of course, the statute contains its own media exemption for media.
But I'm not asking what the statute says. The government's position is that the First Amendment allows the banning of a book if it's published by a corporation.
Because the First Amendment refers both to freedom of speech and of the press, there would be a potential argument that media corporations, the institutional press, would have a greater First Amendment right. That question is obviously not presented here. The other two things.
Well, suppose it were an advocacy organization that had a book. Your position is that under the Constitution, the advertising for this book or the sale for the book itself could be prohibited within the 30-day period.
If the book contained the functional equivalent of express advocacy, that is, if it was subject to no reasonable interpretation.
And I suppose it could even, is it the Kindle where you can read a book? I take it that's from a satellite, so the existing statute would probably prohibit that under your view.
Well, the statute applies to cable, satellite, and broadcast communications. And the Court in McConnell has addressed this question.
Just to make it clear, it's the government's position that under this statute, if this Kindle device where you can read a book, which is campaign advocacy, within the 30-day period, if it comes from a satellite, it can be prohibited under the Constitution and perhaps under this statute.
It can't be prohibited, but a corporation could be barred from using its general treasury funds to publish the book and could be required to raise funds to publish the book using its PAC.
If it has one name, one use of the candidate's name, it would be covered, correct?
That's correct.
If it's a 500-page book and at the end it says, and so vote for X, the government could ban that.
Well, if it says vote for X, it would be express advocacy, and it would be covered by the pre-existing Federal Election Campaign Act provision.
No, I'm talking about under the Constitution, what we've been discussing, if it's a book.
If it's a book and it is produced, again, to leave to one side the question of
forget the
possible media exemption. If you had Citizens United or General Motors using general treasury funds to publish a book that said at the outset, for instance, Hillary Clinton's election would be a disaster for
this. Take my hypothetical. It doesn't say at the outset. It runs here is whatever it is. This is a discussion of the American political system. And at the end it says vote for X.
Yes, our position would be that the corporation could be required to use PAC funds rather than general treasury
funds. And if they didn't, you could ban it.
If they didn't, we could prohibit the publication of the book using the corporate treasury fund.
Here's an example of Paul Clement likely losing a case at oral argument. And to me, Paul Clement is the best SCOTUS oral advocate who has ever lived. And it can even happen to him. And it may not necessarily be just because of this exchange, but you can certainly tell based on what's happening that this is not going well. Let's take a look.
I'm sorry. May I just ask this, just clarify? When they do take away some jurisdiction of some habeas corpus claims, do you defend that in part as a permissible exercise of the power to suspend the writ, or do you say it is not a suspension of the writ?
I think both, ultimately. I mean, I don't think...
Can't be both.
Well, I don't see why I can't have alternative arguments here as where anywhere else, Justice Stevens. We think that Congress, in this action, did not do anything that triggers a suspension of the writ. But if you think that it did, I think...
That's your position. They did not suspend the writ. You're not arguing that it's a justifiable suspension of the writ.
Well, I think that the terms of the suspension clause would be satisfied here because of the exigencies of 9/11. If the question is, am I taking the position that Congress consciously thought that it was suspending the writ, then I would say no. And if you think in order for there to be a valid suspension, Congress has to do it consciously, then I think you could see why the arguments are mutually exclusive. My view would be that if Congress sort of stumbles upon a suspension of the writ, but the preconditions are satisfied, that would still be constitutionally valid. So I think that may be the disagreement.
Isn't there a pretty good argument that a suspension of the writ of Congress is just about the most stupendously significant act that the Congress of the United States can take? And therefore, we ought to be at least a little slow to accept your argument that it can be done from pure inadvertence?
Well, a couple of things, Justice Souter. I would agree with you if what we were talking about is suspending the right as to citizens within the continental United States. But all Congress did here is restore the law to the understanding of the law that had prevailed for 200 years. Now, this Court obviously took a bit different view in Rasul.
If we have to get to the issue, in accordance with Justice Breyer's question, whether or not the writ of habeas corpus was suspended, you are leaving us with the position of the United States that the Congress may validly suspend it inadvertently. Is that really your position?
I think at least if you're talking about the extension of the writ to enemy combatants held outside the territory of the United States.
Now, wait a minute. The writ is the writ. There are not two writs of habeas corpus for some cases and for other cases. The rights that may be asserted, the rights that may be vindicated will vary with the circumstances, but jurisdiction over habeas corpus is jurisdiction over habeas corpus. And it seems to me that the position you have taken is that if at the end of the day we have to reach the question that Justice Breyer described, the answer to that question may be, yes, the writ of habeas corpus was suspended by inadvertence. Congress did not intend to do it. Is that really your...
And is referring to oral argument as a game of Mario Kart, just like lawyers can lose their case at oral argument, so too can the judges lose the position they think is the correct outcome of the case by just doing a terrible job at oral argument. So this is from Justice Scalia, the notorious. And there's an interesting backstory behind this case called Fisher versus University of Texas. This is one of the last cases that Justice Scalia participated in, and actually he ended up not being able to cast a final vote on this case because he passed away in between the time of after the argument was concluded and before the opinion came out. Just listen to this and think, if Justice Scalia had lived, would his side have prevailed? Spoiler alert, it is not a good look.
There are those who contend that it does not benefit African Americans to get them into the University of Texas where they do not do well, as opposed to having them go to a less advanced school, a slower track school where they do well. One of the briefs pointed out that most of the black scientists in this country don't come from schools like the University of Texas.
So they come
from lesser schools where they do not feel that they're being pushed ahead in classes that are too fast for them. I'm just not impressed by the fact that the University of Texas may have fewer. Maybe it ought to have fewer, and maybe some. When you take more, the number of blacks, really competent blacks, admitted to lesser schools turns out to be less. And I don't think it stands to reason that it's a good thing for the University of Texas to admit as many blacks as possible. I just don't think.
And this Court heard and rejected that argument with respect, Justice Scalia. In the Gritter case, the case our opponents haven't asked this Court to overrule. If you look at the academic performance of holistic minority admits versus top 10% admits over time, they fare better. And frankly, I don't think the solution to the problems with student body diversity can be to set up a system in which not only are minorities going to separate schools, they're going to inferior schools. I think what experience shows at Texas, California, and Michigan is that now is not the time, and this is not the case, to roll back student body diversity in America. Thank you, Your Honors.
Thank you, counsel. General Verrilli?
So hypotheticals, oral argument, the name of the game is hypotheticals, and you might get all different kinds of hypotheticals, and they're really the meat and potatoes. This is the sauce. This is the secret to oral argument is the hypotheticals. So let's take a look at how we can answer the hypotheticals, engage with the hypotheticals, fit our case squarely within the jurisprudence with a legal rule that makes sense and is workable for future cases, and transition back to our strongest point. So let's take an example of Paul Clement working some master advocacy.
Suppose that a legislative districting plan is challenged either under the one-person, one-vote rule or under the Voting Rights Act, and it goes to a state or a federal court, and it goes a year before the election. Does the state court have an obligation under the Constitution to simply pass on the validity or invalidity of the plan, and if it doesn't pass, send it back to the legislature, or can it do its own if an election is approaching?
As I read this Court's cases, Justice Kennedy, what they say is that the Court in that instance, first of all, there should be a preference for the state courts over the federal courts. And then the state court favors the legislative process. So what they do is, if there's time for the legislature to go back and draw a new map, they give the state.
And you think that's constitutionally required?
I do think ultimately it's constitutionally required. It's certainly if it's not constitutionally required, it's certainly prudent. And the reason that it's prudent flows from the recognition of this Court time and time again that redistricting is primarily
we're talking about what's required. So if we rule in your favor, we're going to have to tell every court that's involved in a redistricting litigation that it has to submit it to the legislature, even if the court made its own plan for one election. I think it would have to submit it to the back to the legislature for the next 8 years.
Well,
under a reapportionment scheme.
I think for the most part that's what this Court has already said. I mean, White v. Weiser says that in the initial challenge phase that if there's time, you let the legislature do it. Now, this Court has also said, or certainly
you mean a redistricting plan approved by a court has to have a fixed deadline? Of course the legislature can, I assume, pass a conforming plan, but the court's plan stays in place until it does. And it seems to me that that's as much of a displacement as what you're talking about here.
Well,
not as much, but it is a displacement.
Yeah, it is a displacement. It's not as much. I may have been confusing things. I'm talking about there's two different circumstances, right? One is when the redistricting plan is challenged very early, and there's still time for the legislature essentially to take a second crack at a constitutionally compliant plan. And I read White v. Weiser to say that if there is that kind of time, then you allow the state legislature to do it because it's their primary task. Then the second question is there's not time, and then there is a judicial plan, and let's say the first cycle of elections takes place under the judicial plan. Now, I actually read this Court's cases as generally suggesting even then there's nothing that prevents the state legislature, certainly, from going in and redistricting. And this Court, in the Perry case, for example, rejected the idea that it's like you get one shot at this and then you're done for the whole decennial census. Now, there's at least one state, Colorado, that's basically said that if you get into that situation, then you got to live with the judicial plan until the next census. But then the legislature still kicks in and has the primary role. Now, I'm inclined to think that what Colorado's done is inconsistent with the Elections Clause, but however you decide that issue, you could decide it either way. Your position in accepting our argument here does not foreordain the answer to that question. And that's why I'm very happy to address the hypotheticals, but I do think it's worth remembering that this is about the most extreme case that you're going to have. So if the Election Clause means anything at all in terms of its delegation of this responsibility to the state legislatures, maybe we can talk about taking part of it away, but they can't take the entire thing away on a permanent basis and give it to a commission that's defining feature is that it's not representative. If I may reserve the balance of my time.
Thank you, counsel. Mr. Fagan?
And as I mentioned earlier, you need to know where to draw the line. This is Carter Phillip. He is one of the most rhetorically powerful, gifted oral advocates with tons of experience. He's one of the good ones. I like listening to him, for sure.
The paragraph that Justice Breyer's referred to multiple times also has a quote from a Justice Scalia concurrence, which says that the 21st Amendment empowers the state to require that all liquor be sold by an in-state wholesaler. In other words, that is interpreting the three-tiered system, I think, to entail favoritism of in-state interests.
But see, we would regard ourselves as an in-state retailer within the meaning of that. We have satisfied every condition necessary to operate in-state, with a presence in-state of a very large facility that can be examined, can be determined to be in compliance, can satisfy every single one of the states.
Mr. Phillips, I'd agree with you on that, but I would think that the next case would be, much as we've re-examined Quill, for example, and the requirement of physical presence in state, that the next lawsuit would be that, yes, this three-tier system is in fact discriminatory by requiring some sort of physical presence in state. And under the Dormant Commerce Clause jurisprudence, you have a point. You have a good point. So why isn't this just the camel's nose under the tent?
Well, if only because under these circumstances, as the camel, at least, or I guess I'm the nose of the camel, that's not what I'm looking for. I think
you may be, yes.
I am not. It is fundamentally at odds with my client's business model to be looking to undo.
But isn't the next business model just to try and operate as the Amazon of liquor?
No, Amazon wants to operate as the Amazon of liquor, I said, or may at some point. No, my client operates on a brick and mortar business model that says we're perfectly comfortable operating within the sphere of regulation that the state imposes on every in-state operator. And all we are seeking to have is not to be discriminated.
But to go back to Justice Gorsuch's question, I mean, I'm trying to figure out what kind of opinion we could write, Mr. Phillips, that says you win, but then when the next case comes along, and the next case is somebody that says, we don't like this brick-and-mortar stuff. We don't want to have any physical presence at all. And the state is preventing that, and in doing so, the state is discriminating against out-of-state companies. And, you've said that that's not valid, so we're entitled to do what we want to do, too.
I think there are two ways you can go about this. The first one would be, you can write an opinion that just says Bacchus again. This is really protectionist and ought to be declared unconstitutional. Leave for another day the rest of those kinds of issues. The second one is, if you want to take up the question and say, why is brick and mortar more important? Well, brick and mortar is fully consistent with the three-tier system. And we'll leave for another day whether the three-tier system, if it in fact
we're leaving
operates.
A lot of things for another day, but they all seem to be demanded by the principles that you're asking us to adopt.
Well, I don't think so. The principles I'm asking you to adopt is to not discriminate against us under these circumstances where we are clearly, exactly, identically situated and where the state's interest in protecting against alcohol can be fully protected. And leave it for another day if there are other rules that are challenged to see what those rules are.
So there's tons of questions that you're going to get at oral argument and hypotheticals that are predictable. So here's an example of an attorney who is prepared to address a predictable argument head on with an answer ready to go. And I recommend doing that because if you're prepared, it's almost like the question doesn't affect you. You're ready to address it head on. You're still moving forward. That question didn't do anything because I knew it was coming. And here I am ready with my answer.
We'll hear argument now in number 04480, MGM Studios versus Grokster Limited. Mr. Verrilli.
Mr. Chief Justice, and may it please the Court, copyright infringement is the only commercially significant use of the Grokster and Streamcast services, and that is no accident. Respondents deliberately set out to capture a clientele of known infringers to stock their services with infringing content. They intentionally and directly promote infringing use of the service. They support infringing use of the service, and they directly...
Just interrupt with the one. You said the only significant use. There's a footnote in the red brief that says the figure is some 2.6 billion legitimate uses.
Yes, Your Honor.
Correct or incorrect?
Well, I think it's an absolutely incorrect assertion of reality, and perhaps I could delve into it and explain why. The evidence in this case, which was presented at summary judgment, showed that 90% of the material on the services was either definitely or very likely to be infringing.
Was there a finding of 90%?
Well, this was submitted on summary judgment, Your Honor, and we lost summary judgment, so the evidence has got to be construed in the light most favorable to us. And the Ninth Circuit decided the case on the assumption we submit of 90%.
Here's another example of just getting your stuff in. What if this was pro wrestling and Stone Cold Steve Austin didn't get to deliver the Stone Cold Stunner? Or what if The Rock didn't get to deliver the People's Elbow? Do you think they would have won that match? Probably not. You need to get your stuff in. This type of oral argument game is so fast and so complicated. There's so many questions, and so it's difficult to get your stuff in. But Neil Katyal, one of my heroes, did get his stuff in.
Would any reasonable observer reading this proclamation, without taking into account statements, think that this was a Muslim ban? I mean, I think there are 50 predominantly Muslim countries in the world. Five predominantly Muslim countries are on this list. The population of the predominantly Muslim countries on this list make up about 8% of the world's Muslim population. If you looked at the 10 countries with the most Muslims, exactly one, right, Iran, would be on that list of the top 10. So would a reasonable observer think this was a Muslim ban?
If it were just the text of the order alone, it might raise eyebrows for fit and other reasons that the briefs go into, but we wouldn't be here. We absolutely agree that it's the same test as in Lukumi and other cases. You have to look to all the circumstances around it that are said, the publicly available ones. You know, in Justice Alito, the fact that the order only encompasses some Muslim countries, I don't think means it's not religious discrimination. For example, if I'm an employer and I have 10 African Americans working for me and I only fire 2 of them, I don't think, and say, well, I've left the other 8 in. I don't think anyone can say that's not discrimination.
No, I understand that. And it is one of our fundamental values that there is religious freedom here for everybody, and that adherents to every religion are entitled to equal treatment. My only point is that if you look at what was done, it does not look at all like a Muslim ban. There are other justifications that jump out as to why these particular countries were put on the list. So it seems to me the list creates a strong inference that this was not done for that invidious purpose.
Justice Alito, I think if it were just the list, I think we'd be right. You'd be right. Although I'd point out that you yourself in the Storman's case said that it raises an inference of religious gerrymander if, quote, the burden imposed falls almost exclusively on those with religious objections. This is a ban that really does fall almost exclusively on Muslims, between 90.2% to 99.8% Muslims. And so it does look very much like what you said in Storman's. But even then, we wouldn't be here if it weren't for all of the different statements. And the best evidence of this, about what a reasonable objective observer would think, is to look at the wide variety of amicus briefs in this case from every corner of society, representing millions and millions of people, from the U.S. Conference of Catholic Bishops, which calls it, quote, blatant religious discrimination.
Neil Katyal was an acting Solicitor General of the United States, and a lot of the best all-time oral advocates were Solicitor General. It's been said that the Solicitor General is almost like the 10th justice. If you're an advocate, trying to be the 10th justice is the best thing you can do. It's the goal. You are the 10th justice, Neil Katyal.
Might not the act also function as a retroactive approval of what the President has done?
Certainly there's nothing in the text of the act itself, and even I know this isn't relevant for you, but for other individuals on the court, there's nothing in the legislative history or even even the brief filed by Senators Graham and Kyle which suggests in any way that this was ratification. But suppose it were, Justice Scalia. Suppose it did ratify some sort of military commission. I don't believe that it authorized this military commission with this charge, conspiracy, in this conflict, a stateless, territorialist conflict, with these procedures that violate the UCMJ. So it may be that they authorized something, but even that, I think, may be a bit hard because, after all, what they did was authorize, as Justice Alito said, certain challenges to military commissions.
Do you think as a minimum that they authorize a military commission?
They author it. I think it's perfectly. It is a possible reading to say the DTA authorized some sort of military commission. The text doesn't say so. It is, of course, addressed to the jurisdiction of this court and not in any way to the underlying merits. I do think that there is a conceivable argument. However, the reason why I think this Court, if it did decide to reach that ultimate question, should reach it against the government is that that kind of backdoor kind of approval by inference has never been sufficient when it comes to authorizing military jurisdiction and the most awesome powers of the government to dispense life imprisonment and death. That is, I think a clearer statement would be required in this unique setting because we aren't talking about, after all, minor things. We're talking about the most grave powers of our government, the power to dispense life imprisonment and death. And I certainly don't think Congress, on the basis of a few hours of debate, intended to ratify this entire apparatus. If I could turn to question 2 and the Geneva Conventions, I'd like to start with Common Article 3 and its minimal baseline requirements that a regularly constituted court be set up, and one that affords the rights indispensable to civilized peoples. As Judge Williams found below, that article does apply to Mr. Hamdan and protects him. It's the most minimal, rudimentary requirements that the United States Senate adhered to when it ratified the convention in 1955.
By the way, there's a particular moment in a particular oral argument I will not address. I will not discuss what happened in the case of Barr versus the American Association of Political Consultants during the presentation of Roman Martinez. I will not be discussing that, but I may, if you want, discuss it in the comments. Okay, I think we're on the same page here. So here's an example of what to do when you know your opponent's case is a loser. You can basically go up there and say, Your Honors, I really am not concerned whatsoever about any question you ask me because I know that as bad as my case is, it's still way better than their case. And I know you agree with me. So here's an example of one of the smoothest operators at the lectern, Canon Shanmugam.
That they can't stop them from leaving. Have you said that? They can't stop them from leaving?
They can't stop them from leaving if they blank.
They can always proceed to execute the warrant when they see an individual leaving. And if they are in the course of executing the warrant, a detention is permissible. But let me say just one word about the issue of the administrability of the rule, because after all, what we're talking about here is a bright-line rule. And the very purpose of a Fourth Amendment bright-line rule is to provide guidance to courts and officers alike. It is true that one can posit difficult hypotheticals under our immediate vicinity standard, but it is also true that it is even easier to posit difficult hypotheticals under the as soon as reasonably practicable standard that the government advances, which really reintroduces the very case-by-case analysis that bright-line rules are designed to avoid. And in addition, it is entirely unclear to us what Fourth Amendment purpose that limitation serves, because it is not clear to us why it matters for Fourth Amendment purposes how quickly officers effectuate the detention. And just one last point that I'd like to make before reserving the balance of my time for rebuttal. The rule that the government seems to be advocating before this Court is really a much more ambitious rule than we've even been discussing this morning. The government seems to suggest that the government has the authority to detain any individual with a connection to the place to be searched. And I think that that is out of recognition that an individual who happens to be at their workplace could just as easily return to the place to be searched as an individual who is seen leaving. In our view, that is an astonishing extension of the rule that this Court announced in Summers. And I would like to reserve the balance of my time.
Thank you, counsel. Mr. Wall.
Mr. Chief Justice, and may it please the Court.
Mr. Walsh, would you direct your
first response to that last issue, because as I read your brief, you seem not to be accepting the Second Circuit's rule at all. You seem to be proposing what appears to me to be a much broader rule that says, at one point in your brief you state that it is the occupant's observed connection to a home subject to a valid warrant, not his physical location at the time that he's detained, that makes him subject to detention.
One of the toughest things about oral argument is trying to figure out a way to answer on the fly a hypothetical that you've never thought of before. And the key is trying to avoid those situations through diligent preparation. But there is sort of a formula to dealing with this type of situation. It's knowing the framing of your argument and being able to compartmentalize your argument into a nice tight package which can respond to almost any question. So here's an example of Paul Smith.
But if you go back to colonial times, really, the laws not only were different, but look at the prosecutions. And they did prosecute people for sex crimes, but they didn't prosecute people for same-sex crimes. And then if you go across the history, it's only recently that people have been prosecuted for same-sex crimes. But is that a fair characterization? What is the real record?
The argument about 19th century enforcement is that they didn't prosecute anyone for private and consensual crimes involving adults, that they worried about children, they worried about public activity, they worried about coercion, but that they didn't worry about same-sex or different-sex sodomy. Now, as to the equal protection point, which I think I should get to in my remaining time, this is a statute which, in addition to intruding into that area of important fundamental protections, limits its focus just to one small minority of the people of the state of Texas. It says that these specified forms of sexual intimacy called deviant sexual intercourse are illegal only for same-sex couples and not for anyone else in the state of Texas.
What about a statute that covered both?
Well, I think that would be unconstitutional under my first point, Your Honor. Right. I think this is a multiply unconstitutional statute because it does the second thing as well. It says that
if the statute covered both, would there be an equal protection argument?
If there was a record of enforcement almost exclusively as to same-sex couples, I think there would be potential constitutional problems there. But the statutory language itself would not involve an equal protection problem of the same sort that we're dealing with here.
Mr. Smith, aren't there a lot of statutes like that? Aren't there statutes in many states about adultery that don't cover sexual relations of one of the married couple with someone else of the same sex? Are they unconstitutional because of denial of equal protection?
I don't know whether statutes actually are written that way, Your Honor. The point I would make is that when a statute...
What about rape laws? There are rape laws that only apply to male-female rape.
That may be as well. I think
you think that they're unconstitutional?
I didn't suggest that they're unconstitutional. My point is that when a statute is limited to one particular group of people, particularly a minority of people in the state, that limitation itself has to be justified under equal protection, that's a classification of people, not merely a definition of conduct, and that the justification of the line that was drawn here is insufficient as a matter of mere rational basis analysis.
There's more than one way to skin a cat. There's more than one way to win, and it's okay to make alternate arguments.
Can the mandate be viewed as a tax if it does impose a requirement on people who are not subject to the penalty or the tax?
I think it could, for the reasons I discussed yesterday. I don't think it can or should be read that way, but if there's any doubt about that, Your Honor, if it is the view of the Court that it can't be, then I think the right way to handle this case is by analogy to New York against the United States, in which the Court read the shall provision, shall handle low-level radioactive waste, as setting the predicate, and then the other provisions were merely incentives to get the predicate met.
So you're saying that all the discussion we had earlier about how this is one big uniform scheme in the Commerce Clause, blah, 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 it really doesn't matter. This is a tax, and the federal government could simply have said, without all of the rest of this legislation, could simply have said, everybody who doesn't buy health insurance at a certain age will be taxed so much money, right?
It used its powers together to solve the problem of the market not providing
but you didn't
affordable
need
coverage.
that. You didn't need that. If it's a tax, it's only
raising
money is enough.
It is justifiable under its tax power. If I may reserve the balance of my time.
Thank you, General.
During our oral argument, as they keep saying, it's Mario Kart and there's so much going on and there's so many opportunities to miss a detail.
Now, I realize that my friend from the Solicitor General's office said today at the podium that they can imagine that this fraud would have an effect on the regulated market. They did say the opposite in their briefing in the case. Their brief at the cert stage said there was no possibility that there would be an effect on the regulated market. And so this, I imagine...
Can you just give me the page for that?
Yes, sir. I'll get it it's quoted multiple times in our brief. But my colleagues will get it if you don't mind, and it's in the cert stage at about page 12, I think. But I'll have it for you in just a moment, please. And they said there is to quote it almost verbatim, there was no prospect that this fraud would have an effect on the covered securities market.
He does everything right in terms of courtesy, and I really agree with the way he handled it. The question each judge asks is so important. For this type of thing, you kind of do need to pump the brakes and do everything you can to answer it, but sometimes you just don't know. Now, here's a really cool example of a young oral advocate who was specifically challenged and put on the spot.
It's by voluntary action as defined by state law. The state law takes that voluntary action, and it's the state law that makes the consequence, and that's the consequence we're talking about.
Well, Your Honor, I think the questions that Justice Kagan was asking clarify this point. That is to say, if you want to, in this case, talk about what this regulation did in 1976, is it put a conditional stale restriction on the parents who own Lot E.
Well, that's a very fine argument, except for the fact that it's completely contrary to the reasoning in Palazzolo. Justice Kennedy's opinion in Palazzolo rejects that, and the debate between Justice O'Connor in concurrence and Justice Scalia in concurrence is about exactly that. And you don't even cite Palazzolo in your brief, do you?
That is not correct. At pages 41 through 43, we discuss why this is not a Palazzolo-type claim. A Palazzolo-type claim, as Justice Kagan's questions indicated, would be that something happened in 1976 that was unreasonable. And by unreasonable, I mean that it took property without just compensation. So there would have to be a look back to 1976 to see if the relevant takings test fails. And it wouldn't fail here because what happened in 1976? The parents owned Lot E only. And their interest to Lot E was protected by the grandfather clause. The only additional restriction upon the parents that was placed in 1976 by the state was a conditional sale restriction. That is, you can do anything with the lot you want. You can sell it to whoever you want. The only thing you can't do practically is sell it to someone who only wants to buy it if they also own a lot next door and also is substandard. That is a conditional sale restriction, a very minor restriction, and as we pointed out in pages 41 through 43 of our brief, they have not brought that kind of claim, which takes them out of the world of power.
And this is a great example of a tool that you all can use. You can kind of copy what this guy did and try to have ready at top of mind the page numbers that you've discussed your most important cases and the arguments that you're making on those specific pages. Here's an example of what to say when you're making an argument that there really is no precedent for, which is not uncommon. A lot of the cases that come before the court are a new dispute. That's why it's there. Here's the type of answer you can give in that situation.
On the first one, is there any case where all the parties agreed with the decision below and we upheld appellate jurisdiction? Any case?
Where the parties agreed?
All the parties agreed with the decision below, and we nonetheless upheld appellate jurisdiction.
Well, you didn't speak to it in Lovett, Your Honor, but...
No, it wasn't raised. It wasn't raised or addressed, and that had the distinct situation of an appeal, direct appeal from an Article I tribunal.
Well, I don't know that matters because you had satisfied Article III prerequisites to have the case in this court. Now, Your Honor's of course correct that the court didn't affirmatively engage on the issue of jurisdiction, but that is
okay. So putting Lovett aside, since none of this was discussed there, any case?
No, I don't know of one. But Mr.
So this is totally unprecedented.
You're asking us to do something we have never done before to reach the issue in this case.
Let me say two things about that, if I might, Your Honor. First is that it's unusual, but that's not at all surprising, because
No, it's not just that it's not unusual. It's totally unprecedented.
Well, it's totally unprecedented in one respect, Your Honor. If you look at Chadha, okay, this is the second point I'd make. Let me make one point at the outset, though, which is that whether it's totally unusual, largely unusual, I grant you that it doesn't happen. This set of circumstances just doesn't arise very often.
Hopefully you can keep your cool throughout, and one of the things that may help you, it's a sad reality, but at the end of the day, the court can do whatever it wants. You're just the lawyer and you don't have a vote. You can try to be the 10th justice and know the case better than everyone else, but the game is to get 5 votes and you don't have a vote. So it's up to the court to decide the case. It's their decision. They have to live with it and they can do what they want. And sometimes it just is a sad reality. Here's an example.
This has introduced the question of the free exercise clause in this case. We didn't talk about it earlier. And perhaps you want to get on to speech, but in this case, pages 293 and 294 of the petition appendix, the Commissioner Hess says that freedom of religion used to justify discrimination is a despicable piece of rhetoric. Did the Commission ever disavow or disapprove of that statement?
There were no further proceedings in which the Commission disavowed or disapproved.
Do you disavow or disapprove of that statement?
I would not have counseled my client to
Do
make
you
that
now
statement.
disavow or disapprove of that statement?
I do, yes, Your Honor.
What? The Emperor has no clothes.
If you're relying on a specific case, you should know what dicta is. Dicta is part of a court's written opinion that is kind of extra. It's not really necessary to the court's conclusion and the court's legal analysis. It's just in there as kind of color. The dicta is just extra on the side. It's not really part of it. It's just there. And it's a mistake to rely on dicta because it's not authoritative. It's not binding. So here's an example.
Mr. Chief Justice, and may it please the Court. This case, like Oregon versus ICE, involves the kind of finding that the common law never entrusted to the jury. There is, therefore, no erosion or encroachment on the jury function by assigning the function of determining the days of violation to the court for the purpose of determining the criminal fine.
You agree, don't you, that the statement in Oregon versus ICE was pure dicta?
The court's statement in ICE that if a purely algebraic application of Apprendi were followed, it would sweep in things such as fines and restitution was not necessary to the judgment, Mr. Chief Justice, but it was part of the court's rationale in adopting a different take on the meaning of the Apprendi line of cases than had previously been espoused.
And there's certain odd procedures. What do you do if you're asked a question before you're even ready? How would you handle that situation?
Thank you, Mr. Birchfield. General Olson, we'll hear from you. Sometime in your argument, would you cover the question of whether, if the court were to strike down 323A, 323B could survive?
Well, we believe it could, Mr. Chief Justice, but let me come back to that. Thank you, Mr. Chief Justice, and may it please the Court. The issues the Court considers today, every single one of them in connection with Title I, are not new.
What he does is he does answer the question first. He gives a brief answer. Then he has his typical introduction, Mr. Chief Justice, and may it please the Court. And then he does mostly go on to his planned remarks, noting that he will get back to that question. He didn't ignore the question. I think that this is a little bit of an exception to the normal rule because it is a little bit unusual and it's disruptive to the presentation. Just know that this can happen, and this is a good example of how to handle it. The parade of horribles. This is a really common theme in a lot of different cases when you're debating competing legal rules in which one should control. One side will say, well, if the court accepts this, it's going to be doomsday, and there's going to be zombies walking down the street, and gas is going to be $8, and there's going to be burritos for $20.
No, Your Honor. Murder would be considered a lesser included offense of those offenses if the offenses defined by different sovereigns were considered the same as petitioner is urging. But that's not even the only consequence. Even there are a number of categories of cases that would be put at issue here, and I can get into more detail on those in a moment. But before I get to that, even the possibility of claims like this creates adverse consequences for law enforcement, for legislatures, and for courts.
Well, you must think that there's some problem, or you wouldn't have the Pettit policy. I mean, that's an odd defense of a position to say, well, we take care of it somewhere else, so don't worry about it.
Well, no, Your Honor. I think there are a number of instances, including the Double Jeopardy Clause just last term, where plurality of this Court has recognized the Constitution doesn't solve every potential policy problem that may arise, and we leave a lot of those questions for legislatures or for the political branches in general. And I think this has actually been a real success story of that, because he was just asked if he could point to any significant practical problems, and he couldn't. But I can point to a lot of practical problems that are going to arise if this Court adopts his rule. So on the law enforcement side, just the possibility that this could happen is going to deter cooperation, encourage aggressive prosecutions, a race to the courthouse, and defendants trying to play each sovereign off against the other, where one sovereign will have the ability to unilaterally bargain away the other sovereign's ability to enforce its interests. And I'd like to get into some concrete examples of that in a second. But as to legislatures, he said it himself. This would incentivize Congress to preempt state law in more circumstances, and it's going to also incentivize.
What about a case like this very case, a felon in possession? It's the same crime, federal and state. What is the manipulation that you see there?
Well, Your Honor, the examples I would get into, and I'm happy to get into them, are examples of cases in which state and federal interests would be blocked. But speaking to this particular case, I don't think there's any dispute, at least by petitioner, that the federal government has a substantial interest in regulating access to the interstate market for firearms by someone who has twice fired weapons that endanger members of his own family and other members of the community. The only question is whether that substantial federal interest was vindicated when he entered into an omnibus plea deal with the state, where he wound up, as a practical matter, not receiving any additional time in prison for the firearm offense.
Now we have an example of wrapping up with a conclusion. You may find different courts have different levels of patience and leniency, but a lot of courts are pretty strict on these type of rules. And so when they say your time is up, it is up. It means stop, don't keep going.
Let's assume this very case, who would ever have standing on behalf of Congress? Anyone? Or are you saying there's never standing?
Well, there are two different cases. This case is different because this case doesn't involve the kind of unique congressional prerogative that was issued in Chadha. Chadha involved a legislative veto. Here, if I could just finish this.
You can finish your sentence.
This thought. Thank you, Mr. Chief Justice. Here, I don't think the interest that's being asserted is even in the same plane as the one that was asserted and found deficient in Raines versus Byrd.
Thank you, counsel.
All right, now we have a couple of examples of awesome rebuttal.
Jurisdictional. Now,
I don't want to take up from your time, but have you read the footnote that Mr. Clement relies on very heavily?
With respect to conspiracy? Yes, I have. And I do believe the text says that they're referring to domestic offenses. It's certainly the case that conspiracy has been tried as a violation of the laws of war at some point in the Civil War. But that has been entirely eclipsed by the modern laws of war, which have rejected it everywhere. And if you adopt the government's reading, Justice Stevens, that the laws of war are frozen into time in 1916, then I believe there goes the government's case entirely, because the thrust of the government's case is the laws of war have to adapt to this stateless, territorialist organization known as Al-Qaeda. If we're playing by 1916 rules, there is no way that this commission would have been accepted in
Get to the point. Let's say you have 2 minutes. You're probably at most most going to be making 2 arguments. Take a big swing and try to knock these arguments out of the park. This is winning time. This is go time. This is the Game of Thrones. In the Game of Thrones, you either win or you die.
Ms. Blatt, you have 3 minutes remaining.
Thank you, Mr. Chief Justice, and may it please the Court. If you affirm below, you're basically banning the interracial adoption of abandoned Indian children. There's not a single adoptive parent in their right mind who is going to do what the Court below said, which is go through these Kafkaesque hoops of making sure an absentee father's desire to be a parent has been stimulated. This is a private adoption. This is absurd that an adoptive parent would beg the family court to go provide parenting classes. And I wanted you to
Counsel, this act, in terms of voluntary surrender of Indian children by parents, says that it's not final for an adopted parent until the court does the adoption decree. It gives the mother the right, or father, to rescind the voluntary adoption till the very last minute. Has that stopped voluntary adoptions?
No, but this, first of all, I mean, I love that about this case, the irony here. He had no, we didn't need his consent under state law. So the application of 1913, which allowed this withdrawal of consent, mandates the return of the child. Well, there was no way to return this child to anybody other than the mother. And I want you to keep in mind about this case is your decision is going to apply to the next case. And to a apartment in New York City where a tribal member impregnates someone who's African American or Jewish or Asian Indian. And in that view, even though the father's a completely absentee father, you are rendering these women second-class citizens with inferior rights to direct their reproductive rights and their who raises their child. You are relegating adoptive parents to go to the back of the bus and wait in line if they can adopt. And you're basically relegating the child to a piece of property with a sign that says, Indian, keep off, do not disturb. This case is going to affect any interracial adoption of children.
That was its intent. You don't think that that's what its intent was? It only applies to children to tribal children. And the purpose was to establish much more difficult standards for the adoption of a child.
No, Justice Scalia.
Now, maybe you disagree with that policy, but that's clearly
No, I think the policy is fantastic. It was talking about Indian families who were being ripped away because of cultural biases and insensitivity. This case didn't involve cultural biases.
Say that. Its definition
There's 30,000 pages of legislative history that's talking about the removal.
All right, folks, that's what I had to share with you today. I hope you learned a lot about oral argument in front of the United States Supreme Court. This is for the aspiring lawyers out there and the practicing lawyers, all the same, as well as non-lawyers out there. Props to you. I hope you all got something from this. We had great examples of people who really know what they're doing and show us how to get the job done at the highest level. Please like the video and subscribe so you can see future legal content coming from our channel here, Peace in America. One of the things I have coming up is I'm going to do a legal analysis of the movie, The Lincoln Lawyer. And if you like that, I might as well go forward and do a legal analysis of the TV show Better Call Saul. How would that be? You like that? Tell us what you know, what you want to see. Share in the comments if you want to know what happened in that case earlier that I mentioned I'm not going to talk about on video, but I definitely will discuss it in the comments. Go ahead and ring the bell so you get notifications and you can watch our stuff as soon as possible and you won't miss anything. And thanks so much. I really appreciate you watching this, and it's been a lot of fun to share this with you. I really like this stuff. I'm kind of a legal nerd, and so if you like this, I'll keep doing more of the same. Please like, subscribe, stay tuned to our channel, Peace in America, and thank you for watching. Remember to love, dream, smile, and increase the peace.
Like and subscribe, please.
Thank you.